of the data protection law that our parliament is currently, debating on for the past many years, perhaps. And who better than, one of India's most eminent personalities who's been tracking that for a while now, Supratim Chakraborty, who's going to help us to demystify and unravel, some of the finer aspects of that law. Supratim is a partner in the corporate and commercial practice group at Khaitan Company, and has advised many clients in relation to information technology laws in India, including data privacy and cyber security related issues. He has been recognized as a notable practitioner in the IFLR 1000 2020 rankings, and has also been categorized as a recommended lawyer in the prestigious RSG India Report 2019. He is also recognized as a leading individual in the Legal 500 edition for data protection in India. He's been obviously tracking this new law as it develops over the past many months, and has advised and worked with the mighty on aspects that are as part of this law. So I think with that, welcome Supratim, and thank you so much for making time this Saturday afternoon to walk us through that. Let me turn this over to you. But before I do that, ladies and gentlemen, Supratim has let me know that he will present this session in two parts. One is on the law as it stands today, and the second is on the new proposed law that is being debated right now. So please do put up your questions on the chat box all through. Unlike other sessions, we will take a pause at the end of the first half of Supratim's presentation and do a bit of a Q&A on the past. And then once Supratim finishes on the future, perhaps, a second round of Q&A then. So with that, over to yourself, Supratim.
Barzan, thank you so much. I hope I'm audible and you can see my screen.
Yes to both, Supratim.
Okay, great. Thank you, ladies and gentlemen, for your collective time. And thank you, Barzan, for the wonderful introduction. Like Barzan mentioned, I will talk about this in two parts. One is, what do we have as a law today on data privacy and protection? And the second part would be, what are we looking forward to as an upcoming law? Okay, because I truly believe that before you know the future, you need to know the present. Okay. Right. So this will be our route map, really. We'll start off, we'll talk a little bit about jargon such as privacy by design, but again, in very, very simple terms, common day-to-day examples we'll take. We'll talk about data privacy and protection from an organization's point of view. When when you're looking at any organization, what are the kinds of data that you will always observe, okay? And how to look at it from a legal lens. Then we will talk about present day legal framework in India. Then we'll take a break, and then we'll talk about the upcoming personal data protection bill. Some comparison we'll keep doing with the European General Data Protection Regulation, or GDPR, because we are quite inspired by that. Our upcoming law is emulating this law in a way. And then, of course, key takeaways and question and answers can run the way I just mentioned. Before I begin, one very simple point I would like to make, that there is this whole confusion between data privacy and protection. Okay, the two words are interchangeably used, but I would request you to look at it in this way. When you have a glass door or a glass window and someone can look into your room, that's a breach of your privacy. But if someone can break into your room, breaking that glass door or window, that will be breach of your protection. So when you're reading these laws, these provisions, just keep this in mind as we go along. Why do we need data privacy and protection? I don't think I need to belabor to this audience, at least, because they're more than well aware of what has transpired till now, the kind of data breaches that we are observing, and therefore it's mighty important. Let's talk about privacy by design. It's a jargon that is being used, but let's take a simple example. You go to a restaurant, you are about to pay your bill with a card, and they get you a machine like this, which is a point of sale machine. And you will see sometimes that machine will come with a cover, sometimes it will not come with a cover. So the one that comes with a cover is a classic example of privacy by design. So whoever thought of this kept privacy in the center of things, and the job is more than half done. Similarly, whatever people are doing, if whether it is making a product, a service, taking a board decision, if they keep privacy in the center of things, that will solve a lot of privacy related concerns and issues. When you look at any organization's data set, what are the key sets of data? On the right hand side, if you see the large bubble, that is confidential data. Now, this may or may not have personal or sensitive personal data, by the way. So this would be, say, your organization's, IP. This could be your know-how, etc. And how do you protect it? You will have contractual measures, you have tech measures. On the left-hand side, the larger bubble is personal data. Now, this could be your mobile number, your email ID, and how do you protect that? As far as present-day Indian law goes, consent is king. Remember, that's the thumb rule. For only personal data, consent is all that you would require. And when you look at the bubble in the center, which is sensitive personal data or information, such as, say, medical information, health information, your financial information, such as bank account, credit card number, debit card number, all these would be sensitive personal data. And how do you protect that? Remember, there are two pillars. One is, of course, consent. We have already discussed about consent, that you need to obtain it from the data subject. The other pillar is safeguarding that data even after taking consent in a particular manner, which has been set out by law. So that's in a nutshell how you should handle different kinds of data. Let's look at the present legal framework that is there in India. There is no exclusive legislation. The one that will become the exclusive legislation is in the making. It's the Personal Data Protection Bill. But right to privacy has become a fundamental right, and we will keep that premise when we are crafting this new law. Therefore, on a sector neutral basis, you have the Information Technology Act and this long name that you see, Information Technology, Reasonable Security Practices and Procedures, and Sensitive Personal Data or Information Rules, 2011. In short, we'll call it a privacy rules or sensitive personal data rules or SPDI rules. Apart from that, you also have sectoral regulations, okay? Say the Reserve Bank of India giving its diktat to banks and NBFCs on data privacy and protection. Similarly, IRDI giving its diktat to insurance players, so on and so forth. There are other legislations also, like the IPC, the Indian Contract Act, the Consumer Protection Act. All of these today are playing a patchwork of type of role in order to attend to the requirements of data privacy and protection. Now, today we are going to talk about only two sections of Information Technology Act. Idea is not to throw a book at you. It is just to make you aware that there are two relevant sections which is alive today, which you need to keep in mind as you go ahead on this subject. So section 43A deals with sensitive personal data or information. And if you're handling that sensitive personal data or information, you need to have reasonable security practices and procedures. Otherwise, damages will be payable by way of compensation to the affected person. Mind you, this is an uncapped bucket. Now, interestingly, when the European law came in, GDPR, sorry, the penalty was 20 million euro or 4% of annual global turnover, and everyone jumped. In entities which had a EU interface immediately sat up and wanted to comply. Now, interestingly, under Indian law, we always had this provision, which is uncapped damages by way of compensation, but perhaps very few Indian entities would know or follow this. So what is sensitive personal data or information as far as today's law is concerned? Okay, this is a quick take. It's a very important slide. So as far as today's law is concerned, on a sector neutral basis, password, biometric information, sexual orientation, physical, physiological, mental health condition, medical records and history, financial information such as bank account or credit card or debit card or other payment instrument details. These are all sensitive personal data or information. Interestingly, when we go for doing, say, an audit in companies, and we ask, are you handling any sensitive personal data? More often you will see, no, no, we are a very simple small company, we don't handle any sensitive personal data. And then you keep looking and you'll see there'll be biometric attendance at the gate. You will see the HR would be sitting with a lot of medical information, because there is medical insurance which is being provided, so on and so forth. So you have to look at with that lens, that perhaps people would not be aware. Okay, in India we do not have a natural culture of privacy, so therefore you have to make people understand when you are questioning them on handling of sensitive personal data. So our questions have to be dumbed down so that the last person on the ground can also understand. Interestingly, you should also remember that in order to qualify for being a sensitive personal data, it has to be personal data first. So if you see the last line that is there at the bottom of the slide, that's very critical. It says, what is personal information? Information that relates to a natural person, which either directly or indirectly, in combination with other information available or likely to be available with a body corporate, is capable of identifying such a person. Interestingly, let me share this story with you. So we were doing a data privacy exercise with a large format retail chain, and we asked that, are you taking sensitive personal data from your customers? And they say, no, no, we are very clear about that. No names are being taken. We said, okay, fantastic. Let's take a look at your systems. And we observed that when people are purchasing things and they are checking out, at the checkout counter and making payments, they are being asked for their mobile number. And we asked her, what do you do with this mobile number? We were told that, well, we know that to this particular mobile number, the person comes every weekend, perhaps picks up baby products for age group 4 to 5, good spending capacity, and that's how we are tracking these people. And the next question that we raised is, in today's world, how difficult it is to know with certain degree of certainty who this person could be if you have the mobile number and other details as well. So the point is that you should be erring on the side of caution, and it is advisable to read it in a manner that is a little conservative. So if you see, either directly or indirectly, if you're able to identify who the natural person is, then you should always think that yes, it could be falling within the domain of personal information and also perhaps sensitive personal information. If any of these items are triggered, any of these information is being collected, like debit card number, credit card number, your biometric information, so on and so forth. So let's take this interesting case law also. I thought it will be interesting for this group to know. Um, this is in relation to the last element that you see, financial information such as bank account or credit card or debit card or other payment instrument details. Now, many thinkers gave a very myopic or a very restricted view to this particular definition and say that, oh, it's the debit card number and the credit card number, nothing beyond that. So this case law is Amit Patwardhan versus Bank of Baroda. Now, what happened is Amit Patwardhan was working with an organization called Rood India Chains. Okay, on the left-hand side, you can see on the top. After some time, he left this organization and joined a competitor, Heco Chains, which is right-hand side top. And after he joined, the old employer brought a litigation against Amit Patwardhan, indicating that he was passing on critical information about the company to a competitor and was getting paid hefty sums. Now, to establish this, Root India actually produced the salary account statement of that person, of Amit Patwardhan. In retaliation, Amit Patwardhan went to the adjudicating officer of Maharashtra and said that, my sensitive personal data has been breached. How could they lay hands on my salary account statement? It was actually held that yes, the bank account statement is sensitive personal data, and Amit Patwardhan was awarded token compensation. Of course, two things here you need to keep in mind, that even after so much, of I would say a noting by the adjudicating officer that this is not something correct, and bank should be additionally careful, etc. They say the compensation is only 5,000 rupees, and that's perhaps the reason that we will now completely switch to a domain which is much more rigorous in penalty and compensation. The upcoming personal data protection bill is going to have compensation which is akin to the European standards. And also, one other important point here is that the adjudicating officers say that I'm not meting out a higher penalty because even Amit Patwardhan did not come with clean hands. For at least as far as this particular litigation is concerned, perhaps it was not for the adjudicating officer to decide whether Amit Patwardhan had come with clean hands. He was to decide on the sensitive personal data factor. But that's in a nutshell how we have seen litigation and case laws evolving in this space. So if you are handling any kind of sensitive personal data, what you should be watching out for, or if someone is handling, then what should they be doing if any of the sensitive personal data is handled? There should be reasonable security practices and procedures followed. There are norms in relation to disclosure, consent, grievance officer has to be appointed, collection related norms are there, privacy policy has to be in a particular manner, and data transfer requires certain requirements to be followed. I will go through all of these very quickly. Just on the reasonable security practices front, ISO 27001 is one of the reasonable security practices which has been mentioned. For all others, I truly believe it is an inexpensive thing for any organization. It is only about having the right knowledge, okay, which if you are aware, you will be able to follow the requirements in relation to sensitive personal data. So for collection, what you should be knowing, you should collect sensitive personal data only if it is necessary and only for the purpose for which it is collected. Information providers should know that information is being collected, the purpose of collection, the intended recipients, the name and address of the agency collecting and retaining the information. Sensitive personal data should not be retained for longer period than it is required. Information providers should be allowed to review, amend the information provided, and also given an option to withdraw at any time. In relation to disclosure and transfer, we often get these questions. Can I disclose sensitive personal data of my employee or my customer to anyone? Answer is yes, but it should be as per the agreement with the person or after obtaining the permission from the person. Of course, government agencies would always have the leeway if they are mandated by law. Consent needs to be obtained, like I told, and prior consent has to be obtained regarding the purpose of usage. We have had several cases where, say, an employee investigation is happening, and there is this question of, can I look into the person's system and look into the sensitive personal data? So you have to check whether there was a prior consent of any sort obtained from this person, because in a bad day, of course, if you go to that employee and say, I want to check your system, please sign on this document, it could be quite counterproductive and may not be very fruitful. So, you need to be very careful. How did you write your initial employment letter, your IT policy, things which are signed off on? So these are very important to know. Can I transfer sensitive personal data? Yes, of course you can, as per today's law. That is the IT Act on a sector neutral basis. It is permitted to be transferred to any person, anywhere, whether it within the country or outside the country, who ensures the same or equal level of data protection as is given in the rules. And also, if it is necessary for performance of a lawful contract and where such provider of information has given you that consent to do that. Coming next to privacy policy. I have seen, pages and pages written about in privacy policy, but these four very important things which are mentioned in the law are many a times missing, or at least one or two of these are missing. So if you're handling sensitive personal data, you should ensure that you're mentioning the type of information collected, the purpose of collecting the information, security practices and procedures followed, and your disclosure policy. You also need to have a grievance officer, but thankfully there is no benchmark given that the guy has to be a legal officer or an IT professional. No, whoever can handle a grievance, the detail can be given. Name and contact details of the person should be published on the website, and the redressal of the grievance should happen within 1 month of receipt of the grievance. There is another section, like I told, I'll talk about two sections. The second section is section 72A of the IT Act. It deals with only personal information. Very, very critical because it has got a wider net. It is not sensitive personal data. It's any personal data. Okay. So, but this is not to be applied in a employer-employee scenario. This is in relation to a service provider or, a product provider scenario. So if you're providing, say, services and under a lawful contract, you've obtained some personal information without the consent of the person, or in breach of that contract, if you are disclosing that personal information, then you could be punished with imprisonment for up to 3 years or with fine, which is up to 5 lakh rupees or both. So with that, I come to an end of the first part of my presentation, which is about the present day law, especially on a sector neutral basis. I'll pause here, Burzin. If there is any question, very happy to take it now.
Let me just quickly check. Okay, I think there's some stuff on GDPR and what's the relevance of GDPR in India. If you can just touch upon that.
Right. So I think, see, so GDPR would be more relevant when I'm perhaps talking about the upcoming law, but I'll give you a flavor of this answer really. GDPR is considered to be the global gold standard as far as data privacy and protection is concerned. And where is the India, touch point? If you see, our law is also emulating this. So I'll take you to this slide, which will help you understand this better. So this is our upcoming Indian laws context, but just imagine the same scenario in relation to outside EU and inside EU, okay? Now, from outside EU, so where you see it's written foreign company, imagine it's written Indian company, okay? If an Indian company is doing any kind of business in the EU, and replace all India with EU now on the right-hand side, and or you are doing any systematic activity of offering goods or services to data subjects in the EU, or you're trying to profile people in the EU, say through applications, through apps, or say websites, then you are falling within the ambit of EU General Data Protection Regulation. And thereafter, you will have to ensure that you follow their laws. So that's the answer in short version.
Okay, fair. Let me just ask you a question from my side, Supratim. Yes. I've done lots of intro audits over the past many years, and some of what you have just described, while it's very important and could have consequences, isn't really on board agenda. So is it that this law has not been really sort of well used in the past, or has the implementation been lax? I mean, so if all of this is there, then this new law should have come about a lot more easier than the time and the effort that seems to be going into it, right?
Absolutely. I completely agree with you, Burzin. I think people often have neglected or not looked at these sections. There are very few case laws, therefore. Often these are used for the wrong reasons, disgruntled employee, angry customer. These are the people who have used these sections. But in the true sense, this was to empower the data subject or the data principle, as Justice Sri Krishna has mentioned in the upcoming Personal Data Protection Bill. Interestingly, Burzin, he has said, Justice Sri Krishna told that after the Britishers have gone, I would not like to call any of my fellow Indians as subjects. So they will not be called data subjects, they will be called data principals. And the data controller would be known as data fiduciary. I want to establish a relationship of trust between them. Very interesting anecdote, but yeah.
Excellent. Okay, why don't we go on with phase 2 and then we'll come back to Q&A.
Sure. Okay, so let me now go ahead with the upcoming laws. A lot of, we've started this in August 2017, as you can see. And let me again tell you a story here. So Justice Sri Krishna was about to travel to USA. And, our law minister, Mr. Ravi Shankar Prasad, called him and said that, sir, you have to, aapko desh ka ek kaam karna hai. And he said that, okay, can I just come back from my travel and attend to it? He said, no, it's very important. And you have to really, attend to it right now. And he was told that you have to head a committee which will prepare the upcoming data protection bill of this country. He said, okay, fine, I accept. So I think he agreed on a Thursday or a Friday and went off then. On Monday, the government went to the Supreme Court and said that, don't worry, they were getting already pulled up for not there being no law. Don't worry that, soon we will have a law. Justice Sri Krishna will be heading the committee. So now, with the amount of delay that you see, Justice Sri Krishna himself is quite furious because he said that with every passing day, you are denying the fundamental right of privacy to individuals of India. And of course, quite a bit of reiteration has happened, a number of committee consultations. I have been part of several of them, and collectively at Khaitan Co, we have attended every single consultation meet that has happened in the country. Okay, so we know each and every provision inside out, really. Presently, the Joint Parliamentary Committee took the last round of inputs from stakeholders. They're supposed to submit their report in the budget session of the Parliament. Let's see, the last phase is on right now, whether they present it, and thereafter, hopefully within this year, there is a likelihood that this particular bill will become a law, and we will get upgraded to a EU equivalent law. So one of the questions that comes up in most of our sessions is, okay, how much time will I get when this law comes into effect? So there were two versions. 2018 there was a version which Justice Sri Krishna gave basically to the Meiti. It said 18 months. Okay, from the time it is notified, you will get about 18 months. In the new version, that 18 months has been removed. So therefore, the discussion in the in the drafting committee, or people who are in the know, they're saying perhaps this could be brought into effect in a staggered manner, just like your IBC, your New Companies Act. It came in a stage wise manner. Perhaps this will also come in a stage wise manner. So what do we see in the bill? Well, it will have extraterritorial jurisdiction. I already explained to you. The key definitions introduced, sensitive personal data, the definition has been expanded. There are norms such as data localization and cross-border data transfer related stuffs, which is akin to international standards. New compliance requirement will come in. New data subject rights are there, like right to be forgotten, the data portability, heavy penalties and compensation, like I was mentioning, and there'll be a designated data protection authority. On the applicability, I will skip. I think I've just spoken about it, but maybe let me just quickly touch upon on the left hand side. You see, within India, if you are within India and if you are processing any kind of sensitive personal data, then you are squarely covered. Whether you are a state, whether you are Indian citizen entity, you're covered. If there is a foreign entity which is outside the country, but it is carrying out some kind of business in India, or trying to do systematic activity of offering goods or services in the country, or profiling data subjects or data principles in the country, then they would also have to follow the law. I think this is a set of definitions, some of the changes I have mentioned. I'll not go through this, but this is an important slide for all of you. Sensitive personal data. We already went through in the first phase of this particular presentation. On the left-hand side, you see what is sensitive personal data today under the IT Act and the rules. This list is becoming even bigger. In the middle, you will see is the draft bill, what it calls out as sensitive personal data. Thankfully, in the present version of the bill, passwords have been removed because that was the center of controversy. If you speak to the IT folks, you will realize that it is very difficult. If you are considering that passwords would be sensitive personal data, that automatically backed up passwords also perhaps qualifies for sensitive personal data, and it has to be safeguarded in the same manner as has been prescribed under the law for sensitive data. So I think it's a good thing. The fourth bullet point, official identifier, is a very important one. So Aadhaar card, PAN card, all of these will now become sensitive data in the new bill. On the right hand side, I've just done a comparison with GDPR also. They call it special categories of personal data. And this is what they consider as sensitive personal data. Interestingly, if you observe, financial data is not sensitive or special category of personal data in GDPR, but we still are considering. The banks and NBFCs and people in the financial sector had made a lot of deputation. They had requested that if this can be removed, but it still remains. So financial data is actually still sensitive data. Data principal or data subject rights, well, that's one of the reasons why we are having this law. What are the kind of rights that a person can have? So, say it's a customer or your employee can come knocking at your door and say, I want to know what kind of data you have about me. So right to confirmation, right to access, right to be forgotten. Now, interestingly, right to be forgotten, the way it is written in our law is very different from the foreign law. So there are several such examples, but maybe let me pick up this example to tell you how it is not similar to GDPR. So right to be forgotten anywhere would be right to be deleted, for the things to be deleted to the last dot, right? When we started debating about this in Bangalore and Hyderabad sessions of this consultation meet, we realized that it is very difficult technologically to say that I have deleted every iota of every information about you. But what is the menace that the law is trying to really curb? The menace perhaps is that it should not be disclosed further, right against further disclosure. So it is worded in a manner, though the header says right to be forgotten, below that if you read, it's worded in a manner it shows that it's right against further disclosure. Then there is right to data portability, which is basically if you go to bank A, you want to open your bank account, you give your Aadhaar card, PAN card. You go to bank B, again you give your Aadhaar card, PAN card. So the idea is now that can I ask bank A to move this data of mine in a machine readable format from A to B so that my job is lessened and it's a much more seamless movement. So that's where we are moving to. Right of correction and erasure is self-explanatory. Erasure was not there earlier. Okay, in the new version of the bill, this has been brought in. Penalties are pretty steep. Like I told you, there are two primary buckets. One is rupees 15 crore or 4% of total worldwide turnover for certain categories of offenses. The second one is INR 5 crore or 2% of total worldwide turnover. There is imprisonment provision, thankfully, now for only one count. Earlier, it was for many, which is if you're trying to de-anonymize anonymized data, okay, then only there is an imprisonment provision. And of course, there are compensation provisions. Coming to compliances, there are a number of compliances which come in. Privacy by design, I spoke about, notice, safeguard requirements, breach notification, grievance redressal. Then there are a few, like the three with this asterisk mark that you see, is for significant data fiduciary. So higher degree of data processors, say they're crunching a lot of sensitive data, personal data and all that, they will have to carry out an impact assessment, record keeping and data audits, and data protection officer has to be appointed by them. Coming to this whole highly debated data localization problem. Before I begin, let me quickly tell you that there are several theories about data localization. Okay, there is a trade theory, which says that it is my data, my oil, and it should remain in my country because I want to use it the way I want to. Then there is this another theory called security theory, that my law enforcement agency should have access to this data of my people, because as and when we need, we should be able to look at it. I should not go knocking at the door of a foreign player and they tell me that, oh, you please come through mutual legal assistance treaty, which is between two jurisdictions. Sometimes that takes about 11 months. By then the entire the investigation falls flat. So there was this whole hue and cry, and there was a requirement to do a localization or mirroring. Thankfully, further debate happened. What is the position right now under the bill? The present position is personal data can freely go out, no problem. Sensitive personal data, it continues to be stored in India, but conditional transfer is permitted. Critical personal data is yet to be defined. Technically, that cannot leave the country apart from very, very stringent reasons. Okay. So that's all about localization. This is a quick slide for all of you because most of us deal with consents in our organizations for our customers, clients. So where are we headed as a global norm? Uh, Consent must be obtained by a statement, which is a clear affirmative action. It should be freely provided. It should be specific, informed, unambiguous, and capable of being withdrawn. And what should not be is this: it should not be obtained through pre-ticked boxes, or should not be inferred, should not be confusing, ambiguous, unclear language, and it should not be bundled with other terms and conditions. So this is my summing up slide, and I would try to leave as much time as possible for Q&A. If there is lesser Q&A, I would like to touch upon one other element, which is breach notification in a greater detail, because that I think is very important for every one of you to know. So in summary, what did we discuss right now? We should be compliant with the present day laws, because these will continue for some time. We should prepare for the upcoming law, as the global gold principles will not really change. GDPR experience has shown that organizations do take time, and European states, they already had a law It's just one step up. For us, it is a quantum leap. We hardly had any law from there to a European equivalent law. Tone at the top is very critical. So in your organization, you have to ensure that the tone of at the top is critical, is clear. Also, a dedicated team of privacy champions would be required. And if you have systematic and structured approach, then that will make the privacy program a success. So thank you. With this, Burjin, I give the mic to you. If there are
Sure,
any questions, happy to take.
sure. So, okay, let me kickstart. There are several questions here, Supratim. So the first one I think is is now become like almost second nature to all of us, is that we get asked elements of personal data everywhere we go, right? Name and phone number being the least. Sometimes you're asked to also produce a government issued ID, which could be your driving license or a PAN card or an Aadhaar card or something. Including in the current COVID situation, right, where you're required, where these documents are being required for you to register yourself and to get the requisite vaccinations. But keeping that one instance aside, you're giving out your PAN card, Aadhaar card, uh, other details to several agencies in this country. What will happen to that? Will that continue? Will that change? What are the ramifications of that activity?
Right. So I think a splendid question. I think it's a very important question for us to all ponder over. So all these agencies that we are giving our information to, when Justice Sri Krishna was given the mandate and he was told to prepare this law, it was supposed to be an umbrella legislation for everyone. Okay. Government, private players, everyone, and they should be treated almost at par, minus very few exceptions, okay, which maybe the state can enjoy. So that is where we started from. Of course, the 2018 version had all of that. 2019, we saw a little bit of dilution where, there are exceptions which have been created for the state, which is much more. But the sum and substance is the way it should be is that all of this data that has been captured needs to follow the new norm when the law comes into effect. And there is a related question here which keeps cropping up. What happens to historical data? Is there a grandfathering clause? What happens? So usually what has happened for several such laws across the globe is that the law is not really retrospective. It will be prospective. But if you are using some of that old data and processing it further, then that should be as per the new law. Okay, so that's the thought process.
So as I understand, looking at some of your slides, and that's a question come up, is that often the basic information that gets asked is name and your mobile number, but mobile number is not considered to be sensitive personal information, right?
That's right.
Okay, cool. Okay, so the next one then, Supratim, is, while this one deals with more the physical world, let's get to the digital world, where this is, I'm guessing, far more serious issue perhaps than the physical world, right? Uh, this this whole concept, whereby you are leaving behind a digital footprint, which these large sort of tech companies are able to then use AI and other tools to sort of make sense of, and then target you with advertisements or mailers or discount coupons or whatever, right? What happens to that then? And how does that, if at all, get covered as part of this new law?
Right. So I think the first thing which is being attempted here is that your first port of call is the entity to whom you gave that information first. They are supposed to safeguard it in the manner it has been prescribed. But the other thing which you have correctly pointed out is our digital footprint, which is anyways largely available in the public domain. So the idea is that if someone is picking it up even from the public domain, there are safeguards which are mentioned, which they have to nonetheless follow. So I think it is by now, it is absolutely clear that data would be generated. It is up to the players to have the proper procedures implemented so that they are still processing it in the way they should be as per the law. So that's the jurisprudence and thought process behind the law.
So, okay, so let me give you an example that I'd heard, some time back, and check with you how would this be treated going ahead, right? So let's take a scenario of a new employment, and often employers will check social media trails on their potential employees,
Right.
and might find something which is not there in the individual's CV that was submitted. Can the individual claim this is personal information and should have no bearing on that decision? How will that work?
So
Because
I'll tell you how things are happening practically. Okay, what we are observing right now is that mostly large organizations are streamlining their hiring to providing all the information or through a portal, okay, where you have to upload your information and you accept certain terms and conditions there. So there an acceptance is taken that we will be carrying out certain checks on you, and this could be your background check, your social media checks, and all of those. Okay, so we will do that, and you're accepting and acknowledging that this is fine with you. Okay, many a times in the Indian context we have seen that this happens, but it is not made known to the employee or the prospective employee. So that, to my mind, is incorrect, and there is no harm in making it known to the person, like I mentioned, in the manner it's been provided. Like many other checks also happen before an employee, a prospective employee, is onboarded. So this can be just a part of that. Of course, there are other fundamental questions about, that's my private space, is should someone be really looking into it? But that's how the entire ecosystem has evolved, and employers do check some bit of it, because if suppose some radical political posts are there which may not be liked by the employer, then that could be a detrimental factor. Yeah.
so today also, Supratim, the norm seems to be that you either accept all of my conditions or walk away, right, from either my service or whatever. Now, if that service happens to be a fundamental right of an individual, does the law provide for the two being balanced out?
No, the law doesn't really cater to this particular example that you've cited. That's a fundamental right, but the law does cater to the situation where that take it or leave it situation arises for a normal service provider. Okay, so, and in the courts also, you would have seen in the past they're saying that if you do not like it, please log out of that application. Why are you following? Like, why are you continuing? You're bad. You have an X date. You please log off after that, before that, and you're safe. But what this law tries to do is state two things. One is what is important or critical for you to perform that service. Okay, that you should get, right? If you are doing a medical test, you would need the blood sample, right? You cannot say that I will not give you my blood sample, but you have to give me the result. So that is to be given. But information over and beyond that, that is asked. For example, when you download any of those applications, you will see they will take control. They'll say that you sign up for your access of your microphone, your camera, your entire contact list, etc. Now, every time is it required? Answer is no. So those does not come automatically, and that if someone says no to, you cannot deny the service to the person. That's one. Secondly, I would like to touch upon a very important factor of consent in India. Okay, and we debated this at length with Justice Sri Krishna and the committee. We say that what is consent in a country like India, with such large illiterate population, with people speaking so many languages? Are you truly getting consent? Answer is no, perhaps. And therefore, one of the points were taken, and if you see, there's a loose statement in the bill, which states that wherever practicable and feasible, you should have it translated, the policy translated into relevant languages. There were other thoughts also which were floated during the consultation meets, like you should have a pop-up banner, just like your road signs, that that this is not safe, this is not good for you. One piece which was in a way brought in, which I quite like, is the trust score, the data trust score, really. So what happens is it's like a rating which is given to players, especially with those who are crunching a lot of data, sensitive personal data. So when you're handing over the data, if there is a trust score which is already there given, you would be relatively at ease to share that information with them, and that has been incorporated in the bill as well.
Okay. So, sorry, the one part which I didn't see, and I'm not sure if I missed, is that there isn't any requirement for any audit or certification to happen of a company's sort of adherence to all of these aspects. Is there one?
There would be further rules and regulations, but in the interesting part is that I believe 60% of this would come through rules and regulations. Okay. And there would be perhaps further delineation, further detailing of these requirements. So that I think could come in, because anyways there's a hue and cry. Okay. There is a because it's so complex, there is a thought process that it should come in. So to my mind, through rules and regulations, this will be further spelled out.
Okay. So, one of the things that I've seen, through my personal experience is that often data protection falls within the realm of the IT team, right? And at least to my mind, that is only partly okay, because the whole uh, decision point of what to collect, why are you collecting it, isn't of the IT team, but it's of the business team that has requested for that information, right? Could you comment upon that? What are you seeing in the work that you're doing?
Right. No, I think the observation is absolutely correct, because somewhere, and that's where I started off from. This data privacy and protection is all muddled up. Mostly organizations will think, especially mid-level or smaller players would think that this is a IT function, and they're well equipped to handle that. Actually, it is cross-functional. Okay, it cuts across many of the verticals that we have, and there is a legal element to it. There is, of course, IT, there's ethics, all of those. They have to have a seat in this decision making. So yes, now I think is the time when things are becoming a little more streamlined, and I would say people have started understanding that this is not only an IT function, and we see we are seeing a lot of movement around that. Yes.
So in that context, Supratim, what might be your recommendations for my fellow internal auditors in because in terms of if this law is to be tabled in the budget session and gets the consent, and you also mentioned that timing is a little bit of a question mark, right, of when it
Yeah.
actually gets implemented, right? So obviously, apart from knowing what the law really requires their companies to do, what other skill sets do you think they might benefit with in terms of stuff that they should pick up on?
Okay, so first thing, I think, of course, you need to know the law. That is very important. The second thing is that this is a law which has borrowed a lot from the GDPR, okay, the European Union General Data Protection Regulation. So my suggestion would be to read up a little bit about that to understand contexts, because though we have borrowed it, but many a times when we have to understand those concepts, we have to go back and understand what happened, why it was and how it was put in GDPR, also the evolution of it. Burzin, I'll give you a classic example here. These data subject rights that I talked about, like, right to be forgotten, right of erasure, right of confirmation. Under GDPR, what we saw is that, there is a dashboard which was created, and people could log in, make the request, they would get a token number, and, they could fill in their, change their details, or, put in their new details, and it goes back into the system. So automated, really, so technology was providing solution to this complex law, really. Now, unfortunately, what happened is a lot of data theft happened because of that, because people who were not actually the authentic people to have gotten the data got hold of the data, and there was a lot of data theft that way. So what we realized is that this is a learning for India. When you are bringing in such a law, which has got an equivalent requirement, you will have such dashboards in the country. But how do you get, authenticate people who are getting access to it? So similarly, if you keep your eyes and ears open as to what is happening under GDPR, which is 2 years ahead of us, at least 2.5 or a little more, you would be already future ready. So my recommendation to all here is follow slightly what is happening on GDPR, and you will know what you will see in India 2 years down the line.
Cool. I think that's I think very very practical advice. I think the last question that is over here, Supratim, is slightly more technical. Is that will there be any amendment to the existing sort of law that you put out, which is Section 45A? That's what the person has put out. With this new law coming up.
So Section 43A and the set of rules that I spoke about on sensitive personal data will be completely deleted. Okay.
Oh, okay.
The new bill has a schedule which is talking about which are the provisions of law which will go out. And these are two things which have been clearly called out that this will stand deleted. Now, Section 72A, which deals with personal information only, that has not been mentioned somehow. We have again written to the Joint Parliamentary Committee that this has been missed out. Please look into this, because otherwise you will have parallel mechanisms in the country which could be detrimental. So let's see what happens to that. But yes, 43A and the rules are definitely going out, and that would be replaced by the new bill.
Okay. And I just got one more question, which says that and I'm guessing this is more from a technology or digital data, right? That if there is a hack and sensitive personal information gets leaked as a consequence of that, despite the fact that the company can evidence that due care had been taken by them in terms of their sort of security architecture and all the rest, what will be the consequence of an event like that? I mean, will the individuals whose data has got sort of stolen, will they have a remedy, or will the company get away with it?
Fantastic question. Today, Burzin, we do not have any specific legal requirement where the company needs to go to the data subject or the data principal and say that your data has been breached. There is a requirement to report to the CERT in, but that is not also linked to any personal data. This is a general standard set of cybersecurity incident. If you are triggering any of those, go to certain. There's a standard form, fill it in. It has no specific requirement to go to the individuals. Now, what is happening, and that was one of the points that I left and I thought I should cover. This is a good opportunity to cover that point.
Sure.
Is that when there is a breach, what does the new law tell you to do? The new law tells you to go to the Data Protection Authority as soon as possible. But they completely understand that if you mandate and say within 72 hours, go out to the world and say that there has been a breach, you can irreparably harm your business without even knowing whether harm has been caused to personal data or sensitive personal data.
Sure.
Therefore, what you need to do is go to the Data Protection Authority, tell that this has happened. We are looking into it. This is what we have done till now. And there are specific pointers which are given that these are the things at least you should try and give. Now, there is a decision which is taken at that time with the authority that is this the right time to go out to the world and talk about this? If not, please gather more information and come back. Okay. And but if it is too catastrophic, they can tell you that, okay, this is clearly a very big breach. You please go out and inform the data subject, put it up on your website. Also, the authority can put up the details on their website if they think that this is earth-shattering. Okay. I believe that this is a more measured and balanced approach as compared to several mature jurisdictions, because many of them say within 72 hours, go and just declare. We have seen in the tech world, you will see the tech guys, if you speak with them, you will say in 72 hours, you will understand nothing. Okay. I have had situations, right now I'm running a matter where the people don't even have access to their email ID in the first 72 hours. Okay, so they don't know what has happened. Like, it's just grappling at that moment. If they go out to the world and say, oh, we have been breached and, therefore we have come out to you, it will be the end of business, right? So therefore, I believe that the way this has been crafted in the new bill is a good balance between looking at business, and also ensuring that if there is real harm caused to personal or sensitive personal data, then you have to tell the people, you have to tell the authority, and you will be penalized, but not otherwise.
And I'm guessing there'll be more of this spelled out in the rules and
It
the
would be,
regulation.
and another important thing, Bhajan, which you also touched upon, is that demonstrating compliance is
Hmm.
is a very big thing. Okay, it is becoming more important day by day. So all these, say, a data protection session that the entity is conducting, to take attendance sheet of all these people, that they were all made aware that this is the law, this is how you should be handling personal data. In a bad day, that can also come handy. No one
Hmm.
knows, what, if you see those GDPR reporting formats, it will be very clear to you that they're also asking those questions. Did you train your people? Were they aware that they should have handled this data in a particular manner? Now, if you have documented all of that, there is, after doing everything, there's a possibility that things could go wrong. But if you have documented all of that well, and you have a system in place wherein this report can be quickly compiled and given, yes, we have done XYZ, even after that this has happened, but we are still looking into it, these are our further course of action, then the rigor of the law comes down drastically.
Hmm. Hmm. So I guess the message to my fellow employment professionals is all of us are going to have to become quasi-legal professionals as well, because some of this is now going to be all pervasive in almost every area that we touch upon, right? Because there is some element that will get linked, be it in the customer audits that we do or in the IT audits that we do. This will now be an added element that we would need to report upon. And I'm guessing at some point in time, they will request the board to put some statement in some board of directors report and this and that, and then it'll all come back to the internal auditors, very, very quickly. So with that, Supratim, we're almost at the top of the hour. I've been receiving a lot of sort of extremely complimentary comments about your style of presentation being extremely lucid and simple of what is otherwise a very highly technical topic, right? And on a Saturday afternoon, for you to have taken the time and spend that with us, we are extremely thankful. And with that, I would like to close on this session. But before we go, ladies and gentlemen, the next session, which will start at 5:15, is one that we've been eagerly awaiting, and which is the announcing of the awards for the internal audit excellence across the four categories that we had announced a while ago. We've had several entries that came in, and after a very rigorous process, we finally zeroed in on the winners. So please do join us back again at 5:15 as we unveil our winners for 2020-2021. I also want to have a look at the leaderboard. And I can see that there are many people who have sort of upped their game since yesterday. Please do continue, doing that. There are attractive prizes at the end of the last session that my colleague Swami will announce, for today. Unfortunately, individuals who had won yesterday are not eligible for the prizes today as well. We're just ensuring that everybody has a chance to take home some of the goodies that we are putting out. So with that, Supratim, thank you once again, and I will now formally close this session.